Good afternoon, everyone, and thank you for joining us for today's presentation, Fair Housing and Source of Income for Rental Professionals. We're so happy that you could join us on this snowy Tuesday. So we're going to talk about some housekeeping first. So everyone's audio is muted and your cameras are off, so we cannot see or hear you. This session is also being recorded and will be made available on our YouTube channel. If you have any questions, please use the Q&A to ask any clarifying questions about content. We'll have time at the end to answer any detailed questions. If you use the chat, questions may get missed, so please use that Q&A feature. It's on the bottom of your screen. There will be a short break halfway through the presentation. Actually, sorry, I don't think we will be having a break because this is an hour presentation. Sorry, we're used to having longer ones. To verify your attendance, we will have the evaluation link. That should be done by tomorrow by 5 p.m. And then you will receive an email verifying your attendance. We are no longer providing certifications, so please save this email that will verify and confirm your attendance for today's session. And these evaluations will appear in your browser after the webinar ends, and then we will also put the link in the chat. So welcome. My name is Brianna Miranda, and I'm one of the Education Outreach Coordinators. And joining me today, my other co-presenter is Liz Keegan, Director of Education and Outreach.
Hello.
And then Lindsay is on the back end, and they are also an Education Outreach Coordinator. So please, if any of folks you know are having issues logging in right now or have any questions pertaining to technical assistance, please contact Lindsay. And then there is our general information. Feel free to find us on Facebook and LinkedIn as well. And then we just wanted to say thank you. This training was sponsored by a generous grant from the Michigan State Housing Development Authority. And so we are very grateful to MSHDA for allowing us to have a presentation like today at no cost to you all. So kind of the agenda for the day, we will do introductions as we did, fair housing overview, the federal, state, and local protected classes. We're going to talk about what source of income and source of income discrimination is as a broad category, and then kind of focus in what do those protections look like at the different levels. And then what is prohibited exactly under Michigan law, and then best practices and risk assessments, and then we'll take some detailed questions at the end. So if you aren't familiar with who we are a private nonprofit organization that we were founded in 1980. Our mission is to ensure fair housing choice and equal access to housing opportunities for all. We do this through education and advocacy and affirm the right of people to choose where they live free from illegal discrimination. We lead with education and we seek to prevent housing discrimination whenever possible. We are not an enforcement authority and we do not have any practicing attorneys on staff. Because of this, none of the information provided today is legal advice. For legal advice, please consult an attorney. And the information is for educational purposes only and is current to the best of our knowledge, and it can change at any time. And then also just a note, anyone can report housing discrimination. So many of you are housing professionals, but you can also report housing discrimination. We've had cases where a housing professional was discriminated against in trying to obtain housing, but they were also, a landlord. So they knew their rights. These are the various fair housing centers across Michigan. We are the teal area, and then the rest of the state is kind of broken up between various fair housing centers. So please contact your local fair housing center if you aren't located in our service area for questions and other assistance. So before we get started, and I got to tell you all who we are. So I'm going to want to learn a little bit more about who you all are and what your experience is. Sorry about that. Had to navigate. Okay. So the first question is on a scale of 1 to 5. Please rate your familiarity with fair housing. And then the second one, if you have attended our trainings before, this is a little different. We just want to know your experience with vouchers or other sources of non-employment income. How is this something you've experienced? So take a couple seconds here to answer those questions, and then we'll move on to the true and false. Many folks of you are have, are three or above, which is really great. And a lot of you have experience. So that's awesome. I'll end the poll here in probably about 15 seconds. So, and if you're a group of people, you just pick an average. All right, I'm going to end that poll, so get your answers in. Okay. Thank you, everyone. So, yes, like I said, many of you have some fair housing knowledge, so that is really great going into this session because we won't be really covering the other protected classes. We'll only be covering source of income in detail. And about almost 80% of you have experience with vouchers or other sources of non-employment income, so that is a really great starting off part of this training. And then I also just wanted to make note, because I didn't say it earlier, if you did not receive the handouts, Lindsay has posted the link in the chat where you can download them. So please feel free to do that there if you did not get the email. Now we're going to do some true and false questions. The first one, anyone can file a fair housing complaint, a resident, a visitor, a property manager, etc. There was a little hint earlier if you were listening. Fair housing laws don't protect housing providers or their employees, true or false. And then under fair housing law, a person can be held liable for a violation even if they did not intend to violate the law, true or false. Let's give folks about 30 to 45 seconds to answer these.
I can definitely see we have some experienced guests online today. It's very exciting. Thank you all for logging on.
Yeah, some of you folks may have seen these questions before, but these are just good intro questions, get people thinking and understanding, level setting for the day. All righty, I think we got everyone in. Okay, so really great responses on these questions. So it is correct, true, anyone can file a fair housing complaint. So I agree with almost 100% of you. And then fair housing laws don't protect housing providers and their employees. That is false. Although many folks and many housing providers don't feel that they protect them as housing providers or their employees, fair housing laws do that in various ways with harassment and really trying to just make sure everyone is understanding of their rights and their responsibilities. And if you've talked to us before, you can understand various ways that we talk about fair housing laws when it comes to housing providers. And then under fair housing law, a person can be held liable for a violation, even if they did not intend to violate the law. I will agree with 98% of you. It is true. A person can be held liable, even if there was no intention there. So great job, everyone. Yes, Liz said you guys are all some seasoned folks in here, which is great. We love that because you're going to bring some good questions, I see in the future. Okay, now moving on. Sorry, getting my thing to work for me, maybe. So fair housing overview. So we're going to go over the kind of what fair housing is. Again, a lot of you are familiar, but just for those small percentage of folks that aren't, fair housing is the right of individuals to obtain housing of their choice, free from discrimination. And these are based on protected classes that are through federal, state, and local fair housing laws. These laws protect against discrimination in housing transactions, including rental, sales, lending, and insurance. And one thing that we talk about often in our trainings is, why does this all matter? Well, it matters because equal housing means you can choose where you want to live based on what you find important in your lifestyle, what access you have to different things, maybe having a Good employment is really important. So you want to live in a place and close to your job or transportation or access to healthy food or healthcare if you have a lot of health concerns. So allowing folks to have that choice to live where they want and that to be free from discrimination is really, really important because housing affects every aspect of our lives. And then just briefly, here are the federal and state protected classes: race, color, national origin, which is where somebody is from, sex, religion, disability status, which includes both mental and physical disabilities, familial status, which is the presence of children being in the home under 18 or pregnant people. And then at the state level, we have a more inclusive definition of race to include hair texture and protective hairstyles that are often associated with race, marital status, so whether or not somebody's married, single, widowed, divorced, age, however, there are exceptions to senior housing, and then sexual orientation, gender identity or expression, and then newly source of income, which is only protected in the rental housing sphere. And then there are local fair housing ordinances. So if you aren't familiar with your local fair housing laws or ordinances, however they word them, feel free to check those out with your local fair housing center. You can call your local municipality and ask them if they have like human rights ordinance or some type of fair housing discrimination ordinance. And you're also welcome to use these resources. So it's something very important to keep in mind, especially as we talk about source of income protections, because some communities do have their own protections. So what is source of income? When we're talking about the broad term of source of income, it refers to where someone's income is coming from. And the protection is where that income is coming from. So housing providers can always consider a tenant's income and their ability to pay rent and their other financial obligations. However, this protection really prohibits housing providers from saying only only this source of income I accept. So that is really the difference here. The income, the amount of income is not protected. It's where that income is coming from. These protections were really intended to help cost burden families, so people that are spending over 30% or more of their income on rent or utilities, and severely cost burden families who spend 50% or more on rent and utilities to obtain and maintain housing. These protections overall are really to help folks get into housing and really be more inclusive. So what is source of income discrimination as a whole? Refusal to rent or differential treatment based on the source of income, which includes vouchers. Some common examples that we see is no Section 8, screening out tenants with vouchers, so not even, looking at their application because they receive a voucher, offering a higher security deposit. That is a difference in treatment. The impact of this is really when a landlord refuses to make or refuses to accept a voucher or makes it difficult for a person to use their voucher, there's a large impact on the community and on folks and families. It can lead to more homelessness, the government programming. If the person can't use their voucher, then oftentimes they lapse and then that goes back in. And, it kind of creates this effect, this cannot think of the word, but you understand what I'm saying.
Ripple
Ripple
effect, I
effect.
think.
Thank
Yep.
you. Thank you. Ripple effect. A ripple effect. And then often we see more segregation of where people with vouchers are living because only this community or this housing is accepting vouchers. So people tend to congregate in those areas. And then there is this source from about second generation source of income discrimination and first generation, kind of what it used to look like and kind of what it kind of is looking like. And that first generation is really that outright refusal. A lot of folks previously were informed, we just don't work with people like you. And some apartments are for regular people and some are for program people. So really just differentiating people and treating people different, that difference of treatment. And this is still very common and widespread. But then there's also the second layer where there's a lot of barriers when it comes to policies, a minimum income, a minimum credit, more subtle forms of differential treatment. This is becoming more common, and often the policies are explicit. And there are some more subtle forms, but those are hard to detect. Liz, do you want to say anything else on this?
No, I think you covered it very well. I think just I apologize. I do have one point I wanted to make. I'm multitasking here. I think it used to be just very overt or obvious discrimination. There was a case out of New York, in fact, where the staff of the housing were withholding the more desirable units that were available for rent from people who were inquiring, who were voucher holders, using language like some apartments are for quote unquote regular people and some are for quote unquote program people, or these, particular units aren't available for people on programs. So just, being very blatant and upfront about it versus kind of morphing into these areas where it's more policy based, so it looks neutral on its face. But the impact is still essentially there's barriers that make it difficult for folks to use their vouchers and interact with the housing credits requirements, for example. This is where the government is paying. And so a credit score really isn't necessarily a factor that should be taken into account when the government or the resource is paying all of the rent.
Yeah, and I also, this is something that we found after the pandemic, and we've shared this before, but folks that had vouchers within their portfolio as housing providers, they did really well or did better than other folks without vouchers in their portfolio because that money kept coming, regardless if somebody lost their job, that income would go away, but that voucher was still continuing during the pandemic. So that's just something also to think about. This is money that is guaranteed to you. So it's another way to frame it in your mind. So now looking at the specific protections. So source of income protections are really across the board. Yes, we just have them in now as Michigan as a whole, but there are other local protections. LIHTC has some protections when it comes to source of income. So be thinking about that when you are doing your advertising and thinking about this protection, as there's many layers to this. It's not just state law. If you are a LIHTC property, so low income housing tax credit, you are required to accept vouchers as a source of income. LIHTC properties are expressly prohibited from discriminating against voucher holders. Owners are required to certify every year that they're adhering to that requirement. So that is, another layer. You're saying you're doing that. So don't, don't discriminate. And then state housing agencies are responsible for monitoring those property owners for compliance. Now, for Michigan, these did go into effect as of April of last year, and it added source of income as a protected class. The protection states shall not deny or terminate a tenancy or make a distinction, discrimination, or restriction in prices, terms, conditions, fees of a rental lease based on source of income. So that's directly from the law. So what does this mean, though? So protected sources of income benefits, sources of income include benefits or subsidy programs. Oftentimes it is going to be the, housing or public assistance or housing choice vouchers. Sometimes it's veterans benefits, Social Security, other retirement. But broadly, any program that is administered by any federal, state, local, or nonprofit entity is protected. It may also include other types of vouchers or child support or alimony. Like I said, different municipalities have had these protections in. So those municipalities may have different definitions than the state definition. So that is something also to be aware of when you're looking at these protections and understanding them. If you aren't familiar with what HCVs are, housing choice voucher, that is a rental assistance that is funded by the federal government and it's administered by a local public housing authority. So if you're in Grand Rapids, the Grand Rapids Housing Commission is one. I know in Michigan we call them housing commissions, but in other communities they are often called a housing authority. A tenant with an HCV pays a fixed portion of the rent, and then the program pays the remainder directly to the landlord. That's how that program looks. Often can be known as Section 8. That's another lingo for that. if there's other types of vouchers. We just wanted to cover a couple here. This is not a comprehensive list, but some that can be common or you may not be familiar with. VASH program is a Veterans Affairs Supportive Housing program that aids veterans who are experiencing homelessness and their families. This program does include case management and clinical services through the Department of Veterans Affairs. They also have program-based vouchers. This is a form of assistance that is tied to the specific unit and not the tenant. This is often used for specific or affordable housing developments. And then there's the Family Unification Program, which is a type of HCV that aims to keep families together when housing is the barrier or to help youth that are aging out of foster care. So many different types of vouchers when we're thinking of this protection. Source of income does not include, though, according to the Michigan law, any income that is not provided on an ongoing basis or is derived from sources and activities that are not permitted by law. So income has to be legal and ongoing in layman's terms. So that is something that is covered within this protection. It also includes, because we understand or they understand when they wrote this law that public housing authorities often can be a barrier when accepting folks because it has to be, they could drag their feet. And so that was a big concern. So this was added to, again, protect housing providers that, if it's not approved within 30 days, then you can move on, essentially. You don't, if you are being strung along, that would not be appropriate use of this protection. So it is stated that housing assistance must be approved within 30 days if the housing provider provides all the information. So you still have to do your side of the agreement, but so does the housing agency that's administering it. There are exemptions in this law. So Michigan source of income protections have exemptions for smaller landlords with fewer than 5 units. The Michigan Tenant Landlord Act does have this language in there. It does not apply to a person if the person, including all related entities, is a landlord of fewer than 5 rental units. Person does mean individual, partnership, corporation, association, LLC, or other legal entity. And related entity means anyone that is directly or indirectly control of the person. So what does this mean? Under the law, any landlord with 5 or more housing units has to abide by these protections. And this also includes the owner, a person who leases or subleases to someone, any person authorized to exercise any aspect of management for the unit. So this includes property management companies, partnerships, associations, and like I said, LLCs. So if you have multiple LLCs and they have various amounts of units, but one has less than 5 units. You aren't exempt just for that LLC. Your whole portfolio includes more than 5. So thinking of it that way as well, it's you as a person, how many are you in charge of or within your vein? This is a kind of going into that more detail. If a housing provider has several LLCs or a mix of privately owned and some under a corporation, these are all related entities and they are not exempt if there is more than 5. If a property management company is managing a property for an owner who may be exempt, the property management company is not exempt if they manage more than 5 properties. So an owner who is exempt cannot ask a property management company to advertise no Section 8 because that property management company will be held liable to this protection. And now I'm going to turn it over to Liz, who will talk more about what is prohibited under this protection.
Thank you so much, Bree. And I just want to highlight, I'm seeing questions come in and we are going to do our best to answer all those questions at the end of the class. So I'm going to move through more detail on what is prohibited under Michigan source of income protections and give some examples that I hope will be helpful. But, please do continue to use the Q&A feature for questions. You can submit them anonymously if you prefer, and we'll review those at the end of the class because we've had kind of a lightning round come in, which we were expecting and we appreciate. I also want to reiterate that this is a new law, and so we are working very hard to get clarity. We don't have all of it yet. And so we are training from a really conservative standpoint in terms of some of the initial round of questions that we had for the state of Michigan was generally answered with, it's going to depend on what case law comes out of the cases that are brought. So we're focusing on lowering risk today, and I'm so appreciative of you all taking the time to log on and to ask your questions. We do, if we don't have answers, we are doing our best to kind of follow up and try to get more clarity. And when we have that, we'll incorporate it into future resources. So just want to say that quickly before I review the prohibited behaviors under the Michigan law here. Any difference of treatment, any sort of discrimination because of a protected class is when it becomes a fair housing issue. So it follows that because of source of income, if someone is denied or terminated, for an example, a housing provider refusing to rent to someone because they have Social Security income could be a violation. Changing prices, terms, conditions, any fees that are charged, any privileges or facilities or services that are included with the rent for the unit. If those are changed because of where one household's income or one individual's income is coming from, that could be a violation, like charging extra fees, higher deposits, or higher rent because the applicant or the tenant is a voucher holder or has a housing choice voucher, HCV. Not maintaining units occupied by voucher holders to the same standard as other units. This has been all outlined in the law as prohibited behaviors. Not providing the equal access to those facilities and amenities that come with the unit because of where someone's income comes from. So these are from the list of specifically prohibited behaviors under the new law. I'm trying to change the slide. I don't have the power to do that. Because of source of income, it is a violation to make the housing unavailable if the tenant otherwise qualifies. If they tick all the boxes, if the denial is solely related to where their income is coming from, that source of income, that would be a violation. It would also be a violation to represent available units as unavailable or to knowingly exclude them or not talk about them or offer them would be a violation. So examples of telling an applicant with a veteran's VASH voucher that the unit is rented even though it is still available would be a violation. Not allowing available units to be seen or inspected, give that tour, because someone receives alimony as income. Other prohibited behaviors, just overall discouragement of rental. I think one important takeaway is until we have more clarity is to really err on the side of including more people rather than less as kind of a broad takeaway. So discouraging messages would be really prohibited. And then also just adding requirements or changing what your current standards are. So requiring additional references for people that have non-employment-based income, imposing additional or unreasonable screening criteria, ignoring voucher payments when determining if an applicant has enough income to afford the unit. Very common in fair housing laws is it's illegal to discriminate in advertising. So don't publish any ads or make any verbal or otherwise written or communicated statements, email, voicemail, text message, that has a preference or limit because of source of income. So violations would be placing an advertisement for a rental unit that says working people only, no Section 8, employment required, pay stubs required, things like that. Requiring residents to have a job or work a certain number of hours could also be a violation. And then, as with most fair housing laws, people who are protected should not experience retaliation if they try to uphold their fair housing rights here. Also, employees cannot be coerced or forced to violate the law as part of their job. So examples of prohibited language in advertisements, so not a Section 8 building, no Section 8, repeatedly no Section 8 over and over, and even sorry, no Section 8. These are all examples of advertisements that would be discriminatory. And Bree has mentioned it's really important to do that extra due diligence to find out if you have any local ordinances. Quite a few in Michigan have local ordinances that prohibit source of income discrimination. They're really often referencing legal and verifiable source of income at the local level, but here in Grand Rapids, Holland, Kentwood, and Wyoming, and West Michigan, in our service area, we've had those ordinances in place for a long time. Detroit, Ferndale, Royal Oak, Pontiac, Westland, and many more across the state do have local ordinances. So make sure you check the local laws. And it's important to do that because their definition of source of income might differ from what the state definitions and the laws are. So you've got to find a way to make sure you're in compliance with fair housing protections at all levels. So in general, language referring to someone's occupation or lack of employment, or referring to receipt of some types of government assistance really could trigger liability there. And many of you have heard of us always say, describe your property, not the people, and this kind of follows. You don't want to describe the tenant's income either, because that could trip you up under local or state fair housing laws. And as Bree mentioned, the local laws might include a broader definition of alimony, child support, in addition to kind of echoing what the state law says about Social Security and Section 8 vouchers, et cetera. So we're going to review some best practices and kind of apply our learning, but we're looking at a risk assessment, and I'm moving a little fast because I see we've got a good number of questions still coming in. So as I mentioned when I started, and Bree did too, this is still new. So we are learning from other experts who have been working in this area, who have brought source of income cases in other states. We're really doing our best to compile best practices and identify risky practices. So we're continuing to send questions up to the Michigan government and to the Department of Civil Rights. There have not yet issued any guidance, and there are cases that are being brought, and those are still pending. So we're kind of in a space where we don't have all the answers quite yet. So we're really focusing on best practices and identifying risky practices based on how source of income cases in other states and within our local service areas have been decided in court or legal proceedings. So, and just a reiteration, we are not attorneys, so everything that we're sharing is not intended as legal advice and should not be relied on as such. And again, the big takeaway from today is to err on the side of inclusion of more applicants and tenants accessing housing versus exclusion until we know more. That's probably the best risk management approach that we can recommend. So here we have a poll with 3 questions. My poll menu moved around on me there. 3 options to 1 question. Which of these scenarios would be a fair housing violation under source of income protections? It should be multiple choice, so you can choose as many as you would like. Our first one is a voucher holder is charged higher rent because their voucher covers more. Is that a violation? Someone with a voucher applies to a property, but they're denied due to recent outstanding rent and unpaid damages. Is that a violation? And someone with a voucher puts in a maintenance request and doesn't hear anything for a month. Their neighbor who doesn't have a voucher had a similar issue and it was addressed within a week. Would that be a violation? So for the ones that you think are not best practices, go ahead and select those. And I'll give another 30 seconds here. Although you're chiming in very rapidly, I can tell. As we mentioned earlier, we've got a lot of folks with experience on the call, and we appreciate that. So maybe another 15 seconds here. And if I could encourage you to put as much detail into your question as possible, that will really help us provide some answers at the end of our time together. Okay, I'm going to close the poll and share the results. And so we had 91% choose the first option and 88% choose the third option. And I would agree with you. You can hold someone to your screening standards. So if you look at outstanding rent and unpaid damages as part of your normal process, that is something that you could look at and take into consideration under these protections as well. But it would be a violation to charge a higher rent simply because the voucher covers more rent and then not provide that equal treatment in maintenance, as we covered under the prohibited behaviors, certainly would be a fair housing risk as well. So our current best practices include providing equal treatment to all applicants and tenants, regardless of source of income, accepting and counting all income derived from lawful ongoing sources. Watch your communications. Don't express any limits or preferences about income sources or employment status in ads or communications. Work with any agency that's administering a housing choice voucher or other subsidies or assistance in a timely manner. There's that 30-day window. If you're finding that you're having issues with that 30-day window, it might be helpful to inform them of the new fair housing laws and encourage them to be timely to work together there. You want to update your policies and practices if necessary to enter into third-party agreements, like signing the HAP contract, which is part of the process, or get set up to accept third-party payments. And finally, once again, do not retaliate against tenants or applicants who are seeking to use and uphold their fair housing rights in this new area. Okay, some FAQs. We tried our best to think of as many different scenarios and questions as we could. How long is ongoing? This is something we did ask for clarification on, and it's currently undefined. And this is something that will potentially be established through case law. So we don't have a hard and fast answer there. We do know that emergency rental assistance, one-time payments likely are not going to be covered. Does the income have to be consistent? For example, an applicant has inconsistent income from their business. Something that comes to mind here would be more gig economy jobs. You know, you do Uber or Lyft, or you're doing grocery DoorDash type work, and so you don't have the same amount of income posting in the bank account every week. And again, this is undefined. And generally, you know, we would encourage looking at assets or bank statements over time in when we get this type of question, and I think that would apply here too.
Yeah, and just also adding to that, again, the local protections, because
Mhm.
that is kind of more out there. It's more broader types of income in a lot of local protections. So again, that's why it's important to know if your community has those local protections, because it may gig economy type, income may be valid in the local protections.
Okay, so we're going to do another poll about fair housing risk. So we've got 4 scenarios here to look at. Is there fair housing risk if the owner refuses to sign a HAP contract? Number 2, is there fair housing risk if the landlord increases the rent once an application is received from a voucher holder? Number 3, is there fair housing risk if requiring voucher holders only to have co-signers? And our 4th one, is there fair housing risk if a property manager abides by the owner's preference to refuse to include vouchers as income? So hopefully you can plug in answers to all 4 of those. It's a little bit of a risk assessment, which is what we do here at the Fair Housing Center with our fair housing questions and best practices. We want to try to minimize that risk. If you're not able to answer the polls, I apologize. Sometimes it shows up as a separate window and it may be minimized on your taskbar, but we are hearing that Zoom is having some issues as well today, so we apologize. The questions are really more for engagement and nothing required for the course or the training.
I think I also read if you're attending not with the Zoom app and on a
Um,
browser, the polls may not appear.
okay.
And also, if you're attending via a tablet or mobile device, the polls will not appear because it
Mm,
doesn't have that functionality. So apologies for that.
yes.
That's
So,
why we do go over them
mhm,
afterwards, just for folks that may not be able to participate.
yes. And we
So
include
just
them
answered
in
in your
our
head.
handouts too. Yeah, good point, Bree. Technology is great as long as it's absolutely working perfectly. Okay, so I'm going to go ahead and end the poll and we will take a look at our results here. I have a couple things. So if the owner refuses to sign a HAP contract, Oh, Bree, you're going to have to forward. I'm so used to controlling the slide. Yes, that is a risk under the current protections. If a landlord increases the rent once an application is received from a voucher holder, that would be a difference in treatment related to source of income. So yes, that is fair housing risk. In requiring voucher holders only to have co-signers, that's a difference of treatment there. Yes. And if a property manager abides by or goes along with the home's owner's preference to refuse to include vouchers as income, is the property manager accepting some risk there? And the answer is yes. We've actually had this come up in multiple spaces and in multiple ways. The individual owner may be exempt if they don't have more than 5 units in Michigan, but property managers are more than likely going to be managing hundreds of units and they are covered. So we want to make sure everybody's aware of that. So we had kind of a mixed review, but many of you erred on the side of yes, these were all risks. So share those results briefly there. And 85%, 97%, 93%, 92%. So appreciate the risk adverse attitude. All right, next. A couple of risk assessments. The building isn't Section 8 ready. What happens with this? So this statement suggests the landlord is refusing to accept Section 8 vouchers for some reason. This is based on a case out of Connecticut. And in this case, the state appellate court affirmed the lower court, saying evidence was sufficient to show that the landlord engaged in discriminatory practice and damages were awarded. So a better practice or best practice would be to adopt non-discriminatory policies for all buildings and units, including accepting vouchers. And then we have another risk assessment here, refusal to make repairs. What happens if a landlord says, I'm sorry, but I can't take vouchers because my properties won't pass inspection? So again, kind of looking at other communities that have had source of income protections in place for a long time. This is a statement that suggests the landlord's renting properties that don't comply with basic building code. Many communities, larger communities, offer or have minimum standards for rental housing now. So that's something that probably is not going to be defensible. Insinuating the housing may not be suitable for human habitation is also problematic. So there's no administrative burden defense saying I can't bring my properties up to code because the court will likely find that the landlord should be making these repairs as a matter of practice, being in business and offering rental housing under business codes. So a better practice would be adopting a non-discriminatory policy, again, for all buildings and units and include accepting vouchers at covered properties. Landlord adopting a minimum income policy that a person must have an income of 3 times the amount of monthly rent. We don't have clarity other than all income should be counted here in the state of Michigan, but there's been a lot of other communities to learn from. The purpose of this type of policy is to ensure that the tenant can afford the rent, which makes sense. Depending on how the tenant's income is counted, the policy may fail to take into account that the tenant can pay rent in full with their voucher. So this calculation depends on what portion of the rent the voucher covers, many of which do cover 100% of the rent. So better practices would be to adjust income requirements to account for the fact that the tenant has this guaranteed by the government source of income and adjust for the amount. So the Michigan law does say, as a prohibited behavior, landlords shall not exclude any source of income, including vouchers or subsidies, when calculating whether the income criteria have been met. I think we have one more risk assessment and credit to Heather Abraham at University of Buffalo School of Law, who's been doing a deep dive on these protections for a long time and shared some good information with us and other fair housing centers. You might have gotten to see her as one of our speakers last year. Here we have a landlord adopting a minimum credit score policy, requiring a tenant to have a score of 600 as a credit score to be eligible for the rental. Again, the purpose of these policies traditionally is to ensure that the tenant can afford the rent. Credit history is one factor that landlords may consider in determining affordability. However, this blanket policy regarding credit scores may not consider that a tenant with a voucher or has a voucher that can pay the rent. If the tenant has a negative credit history score in their past, it predates when they got the voucher, the tenant may now be able to fully pay. And again, many housing subsidies cover 100% of the rent. So a better practice would be adjusting credit requirements to account for the fact that the tenant has a government guaranteed source of income that may eliminate the need to even consider credit scores. Other risky practices, refusing vouchers because the program is burdensome or you don't want to deal with the government. We've heard off and on over many years that it's been challenging and the law tried to address some of the common concerns of the industry. So we do consider it risky to just kind of have a we don't do that approach because someone could file a complaint and you'd be put in the position to have to respond to that. And we've covered refusal to sign necessary contracts like the housing assistant payment contract also creates risk. Got another poll here. This is a quick one. It is a violation of the law for the landlord to charge a higher security deposit for someone who pays rent with a voucher. So we're checking on your listening skills on this snowy day. Won't leave this one up very long because I'm seeing a rapid response, but we just want to make sure there's some good takeaways that you're getting from the information today. We'll do maybe 30 more seconds. And we just have a couple more slides and then we'll spend a good amount of time trying to get to the questions that I know are still coming in. Okay, I'm going to go ahead and end this poll and share the results. So 95% of you said this is true. So it is a violation of the law for a landlord to charge a higher security deposit for someone who pays rent with a voucher. Yes. We have whoop, one or two more, I think. Two more. Go. Another true and false. It is a violation of the law for a property manager to show fewer properties to someone with a voucher compared to someone without a voucher because of a person's source of income. Okay, I'll give maybe 15 more seconds here. And this one had a lot of agreement, so I'm going to go ahead and end the poll and share that 98% of you said this is true, and it is true. It is a violation to show fewer units because of the voucher. All right, and then I think we have one more, the last true and false. A landlord or property manager is never liable for source of income discrimination if the building they own or manage has fewer than 5 units. Again, this is a Michigan focused training, so we're talking about Michigan law. A landlord or property manager is never liable for source of income discrimination if the building they own or manage has fewer than 5 units. A little bit of a trick question, or at least a question you have to pay close attention to. Okay, I'm going to give you 5 more seconds. Okay. And so we had a split here. And I certainly understand why. The language of the question is if the building they own or manage has fewer than 5 units, but the law takes into account the total number of units that any individual owner, landlord, property manager owns in the state of Michigan. So it's the total, regardless of if they're in one building, if they're on multiple sites, if it's a combination. So this one is false, but a tough question because we slipped in that phrase about the building. But what the law counts is absolutely every single rental property in the state of Michigan to determine if the owner is covered or not. Okay. So we have some what can you do follow-up questions here, but I think Bree and I will get ready for a barrage of reviewing the Q&A, and then we'll end with some housekeeping. How about that? And I think if we go ahead and start at the beginning, we will do our best. Some of these we may have answered. Some of them we may have to get back to you because we don't have an answer. And some of it we're just going to have to say the statute doesn't define or address your questions under Michigan law right now. So if a company only accepts month-to-month rental agreements and deny a Section 8 application, is that going against source of income laws? Without knowing the location, I think there could be some risk here, especially if switching to month-to-month leases was done as these laws were enacted or in response to these laws coming online. Our first question is always going to be why? Why is this the policy? Is this a new policy? When was it enacted? So a little bit of a risk assessment there in terms of we might need to do some follow-up based on local law and get some more clarity, but we'd want to know more as to why that policy is in place, when it was put in place, et cetera. Can a landlord charge market rate for security and deposit of a voucher holder? The best practice is to set your costs and apply them consistently. So I'm assuming this would be a consistent practice where you set your rates and you don't change them. So hopefully that's helpful. It can be a little challenging when we don't have a lot of detail in the questions. Why is it discrimination to say there is an income requirement or credit? So I think that goes back to some of the earlier examples we were giving where some of the better practices might say, is a credit score even necessary for someone who has a full rent covered by a voucher? The past credit score, isn't really informative. So again, it might be helpful to know a little bit more about that, but I think I'm getting at that. And you can have minimum income requirements, but as we've mentioned, there are some best practices to look at in terms of including more people, especially people who are protected under this law. Would a landlord be responsible for discrimination if the housing provider is demanding they adjust the rent to the lower amount, even when it's already under HUD's fair market value? So I'm assuming this is a third party working with a landlord. And I think that's a situation where we would definitely want more clarity and information in terms of what is happening there. What is the expectation of, I'm assuming housing providers, maybe the agency issuing the voucher or holding the voucher. But if you could email us more detail, that might be helpful to understand the players in that question. Is Section 8 valid for Michigan's missing middle housing program, which is normally based on AMI? I'm not familiar with that program. And so I don't want to give any incorrect information about what those requirements would be. I would recommend checking with individual programs to get the data on who qualifies for the different voucher programs. Wouldn't waiving credit requirements be a fair housing violation in that it is discriminatory to those who do not hold vouchers? Okay, I appreciate that question. So people who do not hold vouchers are not protected. So this gets into kind of the nuances of fair housing laws. Similarly to people without children, they are not a protected class. So that would be something if I called Bree and said, I'm being discriminated against, I don't have a voucher, and so I'm not being held to the same standard, I'm not protected. So hopefully that's helpful. And Bree, feel free to chime in here. I'm just trying to move very quickly. Question about approval. I think that goes back to the law in terms of that 30-day time frame. And essentially it's just once once the landlord has done everything to engage with the program, that's within that 30-day window. And I apologize if I'm not understanding what that exactly is referencing, but that's what it brought to mind for me. Is there a direct link available to file a housing discrimination complaint? I tried once and could not easily find it. I think Bree or Lindsay, if you could pop the link into our website. You can also file directly with the state of Michigan online, and the federal government should also have online links. If you're in our service area, which is West Michigan, it's available on our website as well, or you can reach out and contact us directly through our website. In the past, I've had applicants with vouchers that submit legit income documentation to qualify. However, they have their housing caseworker under the impression that they have zero income. In those cases, are we not allowed to inform the caseworker? I think we're going to need a little bit more information on that. I don't think that's going to be addressed by fair housing protections, but I want to understand the full scenario of what is happening there. Is it miscommunication or misrepresentation? Oops. I'm seeing a post about Bayberry Farms Villages. I'm not sure if that's a question.
There's a question after
At the
the.
bottom. Okay, I'm getting there. Sorry, I'm trying to read very quickly. If we have problems with the housing agencies, such as them not processing paperwork for rent increases or them paying on time, do we have the right not to accept? I think that's going to depend on the contract terms. And so I would start with the contract terms and see what you can hold them to, and then compare it to the 30-day protection under the law. But that's kind of a mixed sources of points that would inform, is this something that can be rectified, or what can you hold them accountable to? Can a landlord not allow income from a temp agency where the applicant is not hired in full-time and may not have the income/hours guaranteed or ongoing long-term? Again, we don't have clarification. The statute doesn't address how long income or how long ongoing income needs to be. So I think it may be a helpful starting point would to be looking at, assets or other total household income. We don't have, a magic number to say they have to have ongoing income for X amount of time. We just don't have that. How do you qualify income for Section 8? Do you count the voucher as income, or would you adjust the rent to qualify their portion? The best practice is to count the amount of what the household is contributing. Different vouchers have different calculations, so I don't want to. More specifics would be helpful there about adjusting the rent. If you could send us the full scenario, that would be helpful.
And you're welcome. If a lot of folks did do it anonymously, which is completely fine. If you just reach out to us and specifically tell us information, that also works, like separately in an email or anything. That's definitely welcome.
Program gives notice there's no longer funds after a certain date. I think whatever, that's going to be a mix of following tenant landlord law. And again, looking at that contract, you want to make sure to look at notice. And I think it would be important to see if there's other resources coming online. So I think that would have to be some sort of conversation and looking at a few different perspectives there. And then, following as much as you can consistency, so that they're given the opportunity at least to see what could be done. Whoops, they just jumped around on me. Where was I? If someone does a lease, sorry, Bree, go ahead.
No, I was going to read. I found it. I was just going to read it.
Go ahead. Am I on the right
If
one?
someone does a lease with option to purchase, Section 8 prohibits the option portion. But what is the best way to relay that to applicants and prospects? I'm not familiar with the Section 8 programming. I know there is options that you can turn your Section 8 voucher into, a down payment or change it into homeownership. So I'm not really sure how that works with this specific scenario.
I think that has to be handled on the front end, but I would recommend contacting the local housing commission For example, I know the Grand Rapids Housing Commission has been able to do some purchases with vouchers. I don't know about other outlying areas, but I think it would be good to start with that, the issuer of the voucher for some clarity on that. Does that mean when discussing with applicants? Best practice is to gather as much information about income for the household as possible. So in terms of food or cash assistance, um, are we not able to ask? I also want to know, why are you asking that? Are you asking that to help them qualify, or what's the framework, or how is that information used? So I would want to know a little bit more about that. If a company says a tenant must have an income of 3 times income to rent ratio, what happens when we have a Section 8 application? Is the 3 times guidelines not valid anymore against source of income laws? So one thing that has been put forward as an equitable option is to only apply your 3 times the rent to the portion that the tenant pays towards rent, if any. So in terms of if it's an outright violation, that statute doesn't address that. So I think it's important to count it. And that's something that we're looking for some case guidance on. It just hasn't been issued.
Yeah, just looking at the time really quick, we will stay on a couple more minutes to answer
Thank you.
questions, but I do want to briefly touch on before people log off. So please stay for just one more second. For the evaluation, the deadline to complete is tomorrow at 5 p.m. If you miss that deadline to complete it, we may not be able to verify your attendance any other way, and you will not be able to receive an email verification confirmation. So please complete that survey. And then if you attend with a group, everyone must complete it. And then make sure you share the link out. Will send out the link by email by the end of the day today. However, if you attended with another person, we only have the Zoom records for the person that logged on today. So they will get the link. So please share the link out if you attended as a group. And then just a reminder, certificates are no longer being provided. We are only providing email confirmations. And then that link was put in the chat a couple of times by Lindsay, so please use that. It should be open in your browser. It's in the PowerPoint, so feel free to click it there. Or it may not be actually in the PowerPoint, I apologize. So please complete that, and we will continue answering questions. So feel free to log off if you would like, and we really appreciate you attending with us today.
Thank you, Bree, for joining in for that important housekeeping. Um, Different lease lengths, 6 months, 18 months, and Section 8 declines. What's the best way to handle that? Again, we don't really have good guidance. What's the reason for not offering a 12-month lease? Is that something that could be defended given the protections that are now in place? I think that would be important to evaluate as a risk assessment until we have more. We just don't have any statute definitions to pass along in terms of ongoing income. If someone doesn't qualify for the rental apartment with the income they provided, we're not able to ask them if they receive food or cash. Oh, so if you're including food or cash assistance for household income to try to get them qualified, I think that's more likely to be beneficial to pursue that information, to look at total household income and assets. So we have to accept third-party agreements according to the new law. Again, we're talking about this from a very, very risk-averse point of view. Somebody may bring a case forward that may establish clarity. We're just trying to work with our partners and provide training to help people avoid being on the receiving end of building that case law. We encourage it as a best practice, absolutely. Section 8 typically has higher standards for the state of the unit than local city authorities. What if the housing cannot pass Section 8 inspection due to cost restrictions? So that is something that we have raised as a question, because we've had a couple of specific incidences. In particular, one property needed more than usual, I think, repair. And we were not able to get any clarifying answer in terms of, again, the statute isn't defining that. Essentially they said reasonable repairs. Reasonable isn't defined. So I think that would definitely want to bear further review of risk assessment based on the actual circumstances and actual repairs and cost. And that'd be something we'd be willing to talk about if you're in our service area and see if we can kind of think that through with you. Okay, looks like there's an answer in progress for that one. At a renewal, if a tenant has a voucher and the owner would like to maximize their income, are we able to speak to housing agencies to see what the max value they would approve? I, I'm, I don't think I have enough, I, I'm concerned about that, I guess I would say. I don't know that that's, I think that could potentially be seen as problematic to, um, change rent to meet the maximum value. So you're changing an existing standard. What would be the basis for that? Simply because it's available, or have there been improvements made? So I feel like that could be risky.
Yeah, I would say that's similar to the kind of the question we had at the beginning, changing the rent to match the what the voucher will cover. Again, that's kind of that difference in treatment aspect.
Mhm. By bedroom pricing for a voucher, I don't know if vouchers would allow for that. If there's one of several programs that would allow for that type of rental arrangement, I just don't know. So I apologize, I can't answer that question. Refusal to sign the HAP contract. Yeah, so that's something that we've discussed that there is risk in refusing to sign the HAP contract. Because we haven't gotten any clarification. So again, I think that will be something that possibly is determined by case law, but it's a question we've brought forward. And we were told it's likely a violation and that case law would determine it. Questions about changing the rental increase 3 months after the voucher holder moves in. I think you're gonna have to look at the terms of the arrangement. Um,
Yeah, because that would also affect
both the
your
lease
current.
and yeah, go ahead.
Yeah, I would say that it's gonna, if a property is undergoing a rent increase, I mean, even without a voucher, most people sign a lease and that is the cost they're locked into. So I would overview that goes kind of into, yeah, contracts and things like that. So I would make sure you're following the law when it comes to contracts and abiding by those as well.
Mm-hmm. So I'm seeing a question with from a housing counselor about an HCV amount and asking if there's an accommodation regarding this rule. If you have if you're in our service area, please do reach out to us, and I think it'd be helpful to learn a little bit more about the specifics of where that housing is, and we'd be happy to talk that through with you. I think the location would be helpful. Okay, I've lost, it's jumped around on me again, Bree. Do you know where we are?
Yeah, somebody asked, do we have to accept an applicant who has a 300 credit score if they have a voucher?
I, we need to know more. What's your policy? Are you looking at credit scores already? Are you only looking at credit scores if they have a voucher? So I know it's challenging, not to have a lot of clear-cut answers, but, it's also challenging for us to answer if we don't have a few more specifics. Um, I think we have another kind of similar question about self-qualifying. I think that's also a situation where we're going to need a lot more information about what that requirement entails in terms of pay in full or self-qualifying, or your local fair housing center. If we are not your local fair housing center, I would reach out to them with those specifics because I want to understand what that requirement is. And a question about what can we point to for laws, statute, or ordinances essentially in Michigan, that case law may be built, but there's many other cases, New York, Connecticut, et cetera, that the law was designed to take that into account for those automatic denials. So there's been some movement forward in that area, but not yet here in Michigan that I'm aware of. I think if you were lowering rent to work with someone who's protected under this program, um, again, if you wouldn't lower it for me, but I don't have a voucher, I wouldn't be able to file a complaint about that. Um, I was told to be Section 8, you have to register with the state. I don't believe we're certified. How does that work? Are we okay as long as we don't advertise we are not Section 8? Yeah, if you call and someone asks if you take Section 8 and you say no, that is definitely a risk. I don't know about registering with the state. I think you just would engage with the program that's attached to the applicant, whatever voucher they have that they're bringing to you. You would need to engage with that process, and they need to work with you timely within 30 days. Ah, sorry, it moved on me again. We have a management company refusing to sign a HAP, contract and fill out and sign any documents. Thank you for educating them, providing them with information about best practices. You've given them law, given them the handout. Um, this is wasting the time of the applicants and the resources of the PHA. I would recommend if you're in our service area, I think it would be really helpful to connect with us. Sometimes we can do some education, or connect with your local fair housing center and see if they can do some education to kind of address concerns and mediate there. Because I do think that there is, based on our understanding and the clarity that we've tried to seek, I think there's risk in that refusal to do those documents. I I don't know about Section 8 certification. I think you would want to look at your local programs that offer Section 8 vouchers or housing choice vouchers and different types of vouchers. So I would recommend looking at local public housing agencies, PHAs, housing commissions is generally the language that you would want to look for. You can also connect with your local fair housing center. They may be familiar with groups that would be in your geography. A specific credit score, again, question here about 600 credit score. We'd need to know more about what your policy is and is this unique to voucher holders, and just a little more detail would be helpful there. Same thing with questions about calculating vouchers for calculating income. A good question about grandfathering. If you acquire more than the original 3 properties that you have, my understanding is that as you grow, you would also then be covered. I did not see any language about exempting any properties other than based on the total number of current units owned in Michigan. So I don't think you would have any rights to be grandfathered in at those original properties. If the voucher or subsidy doesn't cover the monthly rental amount, then look at if they have other income that would cover it. They do need to cover their monthly rental obligation, whether it's through voucher plus income, voucher only, other subsidy dollars they might be receiving. If you're in a local city that has ordinances, other things like alimony may count towards their source of income, but they do need to cover the cost of the rent. There's the circling back to a little more detail on the specifics of a PHA demanding a decrease in market rent on the apartment. I think that would be a good idea to contact your local fair housing center in terms of that conversation. I think we need more information before we could make a determination about risk there. Thank you for clarifying that it was the PHA involved. looking at a question about SSA, SSI disability be considered like a voucher. I don't think you need to consider it a voucher. It's just total household income, regardless of what the source is. I think I'm understanding that right. Bree, do you see that?
Sorry, I was trying to go down to get some of the questions that we may have already answered. Sorry, what question are you on?
Looking at correct, is she correct to understand that SSA, SSI disability be considered like a voucher and not requiring their 2.5 months rent income and 600 credit score?
I mean, yes, as Social Security is kind of included in the source of income definition. But again, it would go back to kind of what we've been talking about of um, following your policy or
Yeah,
uh,
I
and yeah,
it's not like a voucher. It's just it's money coming from a different
yeah,
source. It wouldn't have the same requirements as engaging with a
yes.
voucher issuer agency. Okay, now I think thank you. Is it against fair housing to charge late fees if payment is made late? If that was consistently part of policy and consistently applied across the board, I don't think that's a problem. It may be something that is specified if you are working with a housing agency that may be specified in those contracts. So that would have to be checked. I think the location of the person's employment is not relevant. I'm understanding that correctly.
Yeah, sorry, for context for folks, somebody asked about qualifying income from a job in a different location
Mhm.
from which the apartment is located. That isn't really fair housing, but it is something to keep in mind that remote work is very common, and sometimes people have apartments in other cities, uh, you know, things like that.
It's
So,
legal and ongoing income is the factor that should be considered, right? Yeah.
yeah.
So keep an eye on the clock too. A short-term lease be defended based on properties renting easier in the summer. As a defense, I don't think we can answer that. I feel like that depending on how short the lease is, it's laws that it's a dwelling that fair housing laws would still cover. So I don't see an opportunity to take that stance, but again, we need a little more information on exactly what that short term would look like. I see a question about zoning ordinances being changed, and that certainly is we'd welcome more information on that because um, with these source of income protections or with the intent to not include any protected population, even under zoning, could be a violation of fair housing law. So please feel free to reach out with additional information there. I'm trying to find questions that I haven't answered yet. Several properties that have a mix of rural development, housing choice vouchers, and market renters in the same property. These are all different rates. Due to the programs, I think you're relying on the programs to build those rates. So if that's the case, then I don't know that a case could be brought against that because you're following the program guidelines. I think again, kind of asking specifics about the credit score standards. Do we have to accept them if they qualify in all other ways? If their rent is completely covered by the government generated payment, we've seen movement in this area just upholding that credit scores aren't really applicable because the rent is going to be paid by the government. That would also have to be looked at possibly maybe under local protections. But just want to point that out that that's something that, again, we've seen in other states that have been working on this for longer than we have. Okay, a little more detail about an initial conversation and some back and forth about the applicant sharing income information with the housing provider, but not with the caseworker. I I don't think that would be covered by fair housing. So,
Somebody did
um,
try to provide some context that the PHA issuing the voucher will have an authorization to release information for that applicant, and you can contact them and discuss income discrepancies.
thank you, Bree.
Did you get that last one, Liz?
Oh, I don't,
I'm not really sure. So we got a question about 3 times the rent.
yeah, so that's where I talked about if their voucher covers 100% with the, oh, no, sorry, this is a different one. What is the remainder of the requirement? If their voucher is covering,
100%.
yeah, I'm not sure what
I
the
mean, I would
remainder.
collect
Oh,
all income.
oh,
Is
yeah,
that, I don't know, that's the question. I would just show all income that is being, have the person, so the question is if their voucher already covers the income, do they have to show the remainder? I would include all income and assess it that way. But if their voucher is covering the rent, then, you have your answer on whether or not they can,
the rent
uh,
is covered. Yeah. Okay.
I think that is all the questions we got. Again, we apologize as there is a lot of gray area, and this is, again, we're learning along with you
Mhm.
on this information. So as we get more information, we will make sure to, send that out to folks. So if you aren't already included as receiving information from us, please do so. You can sign up for our newsletter, things like that. And then be just checking our website, Facebook, and we'll put information out as we get information on this topic. So we really appreciate you all joining us today. And if you again have any other questions, I did type my email a couple times in some questions, but it is in the PowerPoint. So if it's in the handouts, which will be on our website. Lindsay has posted that link. If you did not get the initial email, that is on our website with that link. That'll be available for the next week. So please download that. And we really appreciate you all attending today. So thank you so much.